violations of the Indian Child Welfare Act. And yes, this is an Indian law case, but the due process, of course, applies to all parents, white, black, whatever, including Indians. Although I should say, in Pennington County, and I don't know about the rest of the state, we just focus on Pennington County, but almost 2/3 of the abuse and neglect cases in Pennington County involve Indian families and the Indian Child Welfare Act. 90% involve, more than 90%, children from one of three tribes. Rosebud Sioux Tribe, Ogallala Sioux Tribe, and Cheyenne River Sioux Tribe, the overwhelming majority, of course, being from the Ogallala Sioux Tribe because they're so close. So here are our claims. We claim that the state defendants failed to give parents adequate notice of the accusations against them, the issues to be decided, and the state's burden of proof. The others deal with the hearing. The state defendants, and specifically the presiding judge, regularly removed Indian children from their homes without basing his removal orders on evidence adduced at the hearing, and subsequently issued written findings of fact that bore no resemblance to the facts presented in the hearing. The state defendants regularly denied parents the opportunity to present evidence in their defense. Opportunity to be heard means just that. None of them were allowed to be heard, present evidence, to speak. State defendants regularly denied parents the opportunity to confront and cross-examine adverse witnesses. Well, they didn't call any adverse witnesses, but they did present, after a while, they began presenting to the court ICWA affidavits or police reports, in the beginning anyway, totally ex parte, and state defendants failed to provide indigent parents with the opportunity to be represented by appointed counsel. The appointed counsel issue was huge because an 18-year-old single mother who did not graduate from high school is not going to be able to represent herself against a trained lawyer for the state. And as the United States Supreme Court stated in cases that we cited, the opportunity to be heard is frequently meaningless without the opportunity to be heard by counsel. So our argument was that due process requires counsel. Section 1922 of ICWA, a great deal of our disagreement with the state dealt with Section 1922, and this is what it says. The first part says that in an emergency situation, state law applies. ICWA does not apply. They can take the kids if there's a real emergency. But, and here's the part that they regularly ignored and violated, the state authority, official, or agency involved shall ensure that the emergency removal or placement terminates immediately when such removal or placement is no longer necessary to prevent imminent physical damage or harm to the child. The emergency, we are in an emergency placement situation until the state has proven and adjudicated a petition charging abuse and neglect. This will typically happen maybe 3 months into the process. So until that happens, it's an emergency placement. What 1922 says is, if you are in that emergency removal stage, the emergency removal has to end when the emergency ends. And they tell you what that means. The emergency is over when removal or placement is no longer necessary to prevent imminent physical damage or harm to the child. That's the legal standard that is supposed to apply in these hearings. The state has a burden of proving, dealing in an Indian Child Welfare Act case, that there is imminent physical danger or harm to the child if returned. If they can't make that proof, if they can't prove that up, the kid should be returned. The state was taking the position. The presiding judge and all the other judges, the state's attorney, DSS, was taking the position, this says ICWA doesn't even apply at a 48-hour hearing. I heard that from the judge many times. This is a 48-hour hearing, Counselor. ICWA doesn't apply here. They took the position that this makes ICWA a statute of deferment, a federal law that was designed to restrict the discretion of state judges and other state authorities. They took the position it was up to state authorities to determine if and when that discretion was going to be restricted. Well, so this was a big part, of course, of our claim that we were saying 1922 means what it says. If the emergency is over, if there is no longer a physical threat to the children, the kids are supposed to be returned. For years, the process had been, are white social workers concerned? That was the legal standard. As far as I could tell, assuming that there was a legal standard. And by the way, you may have noticed, I make no pretense of being impartial here. I do not claim to be impartial. I do claim to be well-informed. In any case, there was no real standard. And what we would hear again and again is, what would often happen in these cases is, a party gone bad. Cops come, somebody gets punched, people get arrested, mom has a warrant for not paying a fine or not showing up to court, and she gets arrested. Nobody to look after the kids. It's an emergency. Take the kids. Absolutely. But 2 days later, they're both out of jail. They're both sober. They're out of jail. Emergency's over. Our position is the children should be returned, pursuant to 1922. But what we would hear over and over again is, well, we have concerns about the parents' alcohol abuse. Or we have concerns. Well, whether or not white government employees have concerns is not a legal standard. The legal standard is set forth in Section 1922. And Mr. Seiler did not give enough credit where credit was due. I want to give credit where credit is due to the United States Attorney's Office, Brendan Johnson, and also to the Department of Justice. Because after we filed our motion for summary judgment, we reached out to the Department of Justice and their Civil Rights Division. And there's a particular office that deals with Indian rights. And we basically lobbied them. We'd like you to get involved in this. And in a brief that was filed and signed by the Department of Justice, by an Assistant Attorney General, and also by Brendan Johnson, who was then the United States Attorney, they joined in, supporting everything we were arguing here in dealing with 1922. Because the United States Attorney, that's part of their job, it's part of their responsibility. They're saying this is a federal statute. We have an obligation to make sure that it's understood and followed, and it is being regularly violated in Pennington County. And a lot of it dealt with Section 1922. So, our 1922 claims, our ICWA claims, were that the defendants have a regular process of not returning the children when the emergency is over. Even though it's allegedly an emergency placement. And we also took the position that if the state court grants the petition for temporary custody, the state court has an obligation to order DSS to return children to their parents immediately when there's no longer when removal is no longer necessary to prevent imminent physical damage or harm to the child. Boiled down to its essence, our complaint was that the state, and the state court in particular, was giving DSS unfettered discretion as to how long, whether to take Indian children into custody, and how long they should stay there. So our position was, of the three main requirements for due process of law, Indian parents and children are denied all three. They don't get a neutral fact finder, they don't get an opportunity to be heard, and they don't get adequate notice. Now, the court This was the ruling. This is the bottom line. The court finds that Judge Davis, State's Attorney Vargo, Secretary Valenti, and Mrs. Van Hunnick implemented policies and procedures for the removal of Indian children from their parents' custody in violation of the mandates of the Indian Child Welfare Act and in violation of the Due Process Clause of the 14th Amendment to the United States Constitution. He specifically ordered and ruled that 1922 is not a statute of deferment. It applies immediately the moment they step into a courtroom at the 48-hour hearings. And the burden, the legal standard, is whether continued placement is necessary to prevent imminent physical damage or harm to the child. And the judge must order DSS to return custody to the children when the risk of imminent physical harm no longer exists. And here's what we were all about from the beginning at its essence. There has to be an evidentiary hearing. The Indian Child Welfare Act and due process requires an evidentiary hearing. They have to put on evidence. They cannot delegate the authority to make custody decision to DSS. There has to be an evidentiary hearing in which they present evidence. As far as the court agreed with this on all 5 of our claims, there has to be proper notice to the parents, telling them that where the hearing is going to be, the purpose of the hearing, consequences, and the alleged factual basis, and a statement of the legal standard. They should be given copies of any documents, this is also an ICWA, that the court is going to rely on in making a decision. There has to be evidence-based rulings. This seems basic, but a court actually had to rule that in cases involving taking people's children away, rulings have to be based on evidence. And the court, to demonstrate compliance, should state the reasons for his determination and indicate the evidence he relied on. Right to appointed counsel. They have a right, parents have a right in that 48-hour hearings to be represented by counsel, which means if they're indigent, they can ask the court, I'd like you to adjourn this case for a brief period of time, 24 hours, to give me opportunity to speak to appointed counsel and come back here with a lawyer to do my talking for me. It's just like being in federal court when you are arrested. They bring you in front of the judge. You have a right to a detention hearing. You want to have that hearing now, or do you want to have it tomorrow with the lawyer? I'll have it with the lawyer. And so frankly, this is one of the issues. We were really sure about the other issues. We weren't 100% confident that the court was going to grant us the right to counsel, but we thought that was so important. And so, but the court did indeed find that due process of law requires appointment of counsel for indigent people. Parents have a right to testify and present evidence in the 48-hour hearings. Now, these are not, by the way, contrary to what the state has frequently said, we're not asking for a full-blown rules of evidence hearing, but there has to be some kind of meaningful evidentiary presentation. Parents have a right to confront and cross-examine state witnesses, as well as the preparer of any documents that get submitted as evidence. Final score, the Indians won 7 claims, the state defendants 0. Now, it's not over. Those were the 7 substantive claims in our lawsuit. One claim we did not raise by summary judgment, and that is we made a failure to train claim. We claimed that people were being violated their rights partially as a result of DSS failing to train their workers on what ICWA requires, specifically Section 1922. That has not been decided. So we will either present a summary judgment motion on that, settle it, or try it. But 90% of the case has been decided. The substantive legal issues have been decided. The state has recently filed motions to reconsider. We're confident that reconsider the summary judgment order. It's a 45-page opinion, by the way. You can see it online by going through PACER or any number of other sources. But after that motion we're confident that the court will deny the motion to reconsider. The next thing that has to happen is the court will then enter specific injunctive orders. What the court did here is grant a summary judgment, but as far as the actual injunctive orders, that's the next step. So the next step is going to be injunctive orders directed to DSS and the state's attorney saying something along the lines of, you may not take custody of Indian children unless you have had a hearing in which these rights have been provided. Under 1442 United States Code 1983, you cannot sue, oh, by the way, we're not suing for money damages, we're strictly seeking declaratory and injunctive relief. You cannot sue a judge for an injunction in 1983. You sue judges for declaratory relief. A declaration of the law. Here is what you are supposed to be doing. And then if they fail to comply with that, then you can seek injunctive relief. So that's where we're at now. The state is taking the position, by the way, that they are not, well, state judges are taking the position, they are not bound by federal court's decision, interpretation of federal law, which in the abstract, I believe is probably correct. However, DSS and the state's attorney are most definitely bound by the federal court's orders, so it's going to be interesting to see how that plays out. We fully anticipate that it'll go to the 8th Circuit Court of Appeals, and we'll win or lose there. I want to say one thing in closing, then I'm going to open up to any questions. Child abuse and child neglect, especially child neglect, are very real in Indian country and elsewhere. DSS, as a rule, doesn't pick parents' names out of a phone book to decide to take their kids. Usually, there are real neglect cases. I mean, when an Indian, and I've been in these hearings every week, in virtually every Indian case, Indian Child Welfare Act, abuse and neglect hearing in Bennington County over the last 3 years, because I represent 3 Indian tribes in those type of hearings. And when a mother, 7 months pregnant, is getting high on methamphetamine and the child is born 3.5 pounds, 2 months premature on methamphetamine, and then the mother walks out of the hospital, that's child neglect. But many of these cases they're not cases like that. 90% of the cases are neglect cases, not abuse cases. And as I say, many of the cases deal with situations that are temporary, that involve some bad parenting, but our position is, the way we see it, children are harmed one way or the other when they are removed from their custody of their parents. When children are removed from a caretaker, even a negligent, irresponsible caretaker, that's traumatic to the children. And so the question is, which is going to hurt the child less? Or really, which is going to hurt the child more? To be returned to the parent, or to experience long-term separation from the parent? When a child is placed in foster care by DSS, normally they're going to see the parent 1 hour a week under supervised visitation. And children do respond with depression, anxiety, separation anxiety. So the purpose of these hearings is to protect children from neglectful or abusive parents or caretakers, and from overreaching by the state. And all we're asking for, seeking here, is a fair hearing in which a neutral judge will make that decision as to whether or not it's so necessary to protect these children, to remove them long-term from their families. This lawsuit has, basically we've done things that nobody's done before. And in Indian law circles, this is followed through, nationwide, because we're using a federal statute to vindicate ICWA rights for Indian parents. I just want to say one thing. This is not terribly, maybe not real important, but I just think it's interesting, and I think some of our clients would think this is a sign. But when the state made its motion to dismiss our case for failure to state a claim, et cetera, one of their claims, one of their arguments, and it was a reasoned argument, was that federal abstention doctrine prevents federal courts from basically interfering in state court decisions. We had to be very careful in crafting our lawsuit. We didn't ask the court to undo any prior state court order or to enjoin any ongoing state court case. Had we done so, the abstention doctrine would have required dismissal. The Eighth Circuit had an opinion that said you can't bring a 1983 action challenging a state court or state court practices if you have a state court remedy. So what would have happened in all likelihood, if the next thing I'm going to tell you didn't happen, is we would have won at the district court level and gone to the Eighth Circuit Court and they'd have kicked us out. But 3 days before Judge Viken, he had already told us, I'm going to get my ruling out on your motion, on the state's motion to dismiss in the next couple of days. About 3 days before that came out, the United States Supreme Court came out with a decision called Sprint Communications against Jacobs, and it unanimously reversed the Eighth Circuit Court and said, it doesn't matter if you've got a state court remedy. If you want to sue them in federal court, you can sue them in federal court. So 3 days before that decision, the United States Supreme Court came out with a decision that saved our lawsuit. And I got a lot of Indian clients who would say, that's a sign, they're with you. So anyway, that is my presentation. If anybody has any questions, I'd be free to try to answer. Alicia.
Hey, I don't know if you can answer this, but it's bothered me so much that I would put it out there. Let's say I have an Indian client and she was 5 months pregnant with her child in custody, and 4 months down the line she's done parenting classes, cooperating with her parents, and then the second child is born. Now, without my client telling me, I don't know when the child is born. All I receive is a amended petition saying that the 48-hour hearing has already happened with regard to the baby, and that this is my notice for the next hearing, the advisory hearing.
Okay.
What is my remedy, if any?
Your remedy is to file a motion for a new hearing, a new 48-hour hearing. There is a state statute that says at that initial hearing, the court must, among other things, give them advice of their rights, including their right to counsel. You can file at that time in the state court a motion not a motion to reconsider, but a motion to vacate the temporary custody order and ask for a new hearing using, among other things, this lawsuit and the court's rulings. They had a right to counsel at that hearing. They didn't get it. They didn't present any evidence. And from there, if and when that gets denied, you could then at least seek a petition, make a petition for an interlocutory appeal to the state Supreme Court. That's what I think is available to you.
Dana, if you have a chance when a question is asked, could you repeat it?
Yeah, right. Okay, well, Alicia just asked what happens if, and this is what happens when they don't appoint counsel. The lawyer gets notice after the temporary custody hearing saying, we just took custody of your client's child. Your next hearing is at such and such a date. What can you do? And this is what I would urge you to do. I think we need to start filing, whether or not we're going to get anywhere with them or not, I think we have to seek remedies in state court by means of seeking interlocutory appeals. And it may be more effective once a final judgment has been ordered in this, but that's what I think your remedy is.
Thank you.
If there's no other questions, I appreciate the opportunity to speak to you.
As I indicated at the start, unfortunately Danny couldn't be here, and I also learned that our other two presenters for the second half of the CLE on the guidelines, JR and Heather Dawn Thompson, couldn't be here today. So unfortunately we're not going to have the second part of this ICWA presentation about the new guidelines. I will point out that in your materials, if you picked up one of the books when you registered, and they will be online afterwards, is a copy of the Federal Register from earlier this year of the new ICWA guidelines. They are in your materials. A copy of the opinion that Dana just went over is also in your materials. So